about disparate impact rule. We're going to talk about affirmatively furthering fair housing, and then I'm going to give you an actual case example of a case that we recently resolved on Section 8 voucher holders and property insurance. Just for a gauge of the audience, any local government, anybody in the real estate industry, public housing, PHAs, just individuals interested in fair housing.
Affordable housing.
Affordable housing. Okay, we're going to talk a little bit about affordable housing. This is HUD's disparate impact rule. On February 8, 2013, HUD issued new regulations about the disparate impact and talked about what would violate the disparate impact. It's an important step forward to equal opportunity, and it's about toppling barriers, and it's for the common good. It's nothing new. It's nothing. The affirmatively furthering fair housing rule is nothing new. We're going to talk about some things and some cute tools and how to deal with the affirmatively furthering housing rule. HUD's disparate impact regulation was affirmed law for over 40 years. All 11 federal circuit courts have affirmed that standard, and every federal court of appeals to hear disparate impact cases have held the FHA provides for disparate impact liability. January 2015, the Supreme Court held oral arguments on the Inclusive Communities Project versus the Texas Department of Housing. This is the famous case right now that we're all interested in for disparate impact. This case was heard by the Supreme Court in June of this year. Fortunately, I was in D.C. while this was going on, and it made significant impact on all fair housing cases, and in particular a case that we were working on specifically at that time. Why is it important? It's a primary civil rights tool based on race, familiar status, disability, and other aspects of who we are. HUD has now provided a level of clarity for individuals, businesses, and public institutions. And in November 2014, the American Insurance Association filed suit against HUD, challenging the promulgation of the disparate impact rule. They did not want the disparate impact rule out there and as a working entity. The continuum has had more significant community impact on disparate impact cases than we have in individual cases. We opened our doors in April of 1995, and predominantly most of the cases that we handled for the next decade were individual cases of housing discrimination. A person refused to rent to me because I had a disability. A person refused to sell to me because of my race in individual cases. HUD has taken the track in the last 3 years that there will do more systemic investigations that have a broader impact on housing discrimination and to look at those more intently. We settled a case 4 years ago called the Spanos case. Anybody know who Spanos is? Their claim to fame is they own the San Diego Chargers, but they make their money by building apartment complexes all over the country. And then they sell those apartment complexes to apartment management corporations. Spanos Company, we entered into a partnership with the National Fair Housing Alliance and several other agencies like ours across the country, and we tested some of the Spanos properties, and we found that they were not building those properties to the accessibility guidelines of the Fair Housing Act. We filed suit against them. They settled that case, and every organization that was involved in it got $50,000 a year for 3 years to do a home modification program. So the impact on this is significantly larger than an individual case. These figures are a couple of months old, but a couple of months ago with that $150,000, we had gotten $125,379 in match money, making for a total impact of almost $300,000. We had done modifications to 359 homes for persons with disabilities who could not either get into their home, in some cases had not taken a bath or a shower other than a sponge bath for up to 6 months because they were afraid they would slip and fall in their tub They would not be able to recover it. So disparate impact cases have a significant impact. 3 years ago, NAFA and 16 other partners decided to test when the real estate market bottomed out. All the banks did all those repossessions of those homes. The banks then owned those houses. So we decided to test those properties, and we found that the banks were not maintaining houses in neighborhoods of color to the same standard they were maintaining houses in white neighborhoods. In the white neighborhoods, they had a very small inventory of properties, 10 to a dozen, because they were maintaining the properties. They mowed the grass, they fixed the windows, they fixed the doors. They had for sale signs out in the front yard so that you knew they were for sale. In neighborhoods of color, however, they were not maintaining those properties to the same standard. They would let the grass grow, they would let vandals come in and break out the windows and squat in those houses, break down the doors, and then other crime and things would just happen. So we filed suit against Wells Fargo. Wells Fargo came to the table almost immediately. It was a $40 million settlement nationwide. $1.4 million went to each organization that was involved with it for community reinvestment. What we do is we use that money with match money to do community reinvestment in neighborhoods that have been affected by the REO properties. We have a project called Heroes Commons in Jefferson Park. It's in Paramore in Orlando. Anybody know Paramore neighborhood in Orlando? We're building 6 single-family homes for veterans with disabilities. We've rerouted the bus lines and transportation so there'll be public transportation to these homes. There'll be continued medical and educational training for veterans with disabilities and first responders. The goal is to have a 0 mortgage. And these community and reinvestment funds are allowing us to do that. We do first-time home buyers with Community Housing Initiative in Brevard County and Hands of Central Florida in Orlando area, where we will assist in down payment assistance. We will assist in loan-to-debt reduction for your mortgage so that you can qualify for your mortgage, or we will help you and assist in remodeling and rehabbing an REO home that's been neglected. Hannibal Square Community Land Trust. Anybody know of Hannibal Square Community Land Trust? It's in the Winter Park neighborhood in Orlando, very expensive neighborhood. There's no way you could really get affordable housing in Winter Park if you did not have the land trust. The land trust continues to own the land, and the affordable home buyer only has to purchase the home. So we assist with projects there. And another project we're involved in is a veterans community in Baade, where previously was a 55 and older community. It's now transitioning to a family community, mobile homes or manufactured homes. In order to get into and out of the neighborhood, you must drive by the VA clinic. We have 2 lots there that we're putting donated manufactured homes on for transitional recovery for veterans going through rehabilitation for their injuries. So that's the kind of things that we're doing with some of the settlement money and the disparate impact cases that we have. Let's talk about the Affirmatively Fair Housing Goal. The panel after meeting this afternoon is going to talk to you more about that, but let's talk about it as how you can use it as a tool. Primary goal of HUD is to improve affirmatively fair housing through the analysis of impediments, which is now changed in the wording, and follow-up action plans. It's nothing new. There's not a thing in this new other than to give you a more concise tool and instructions on how to do it. The things that you're supposed to do, you were already supposed to do for almost the last 20 years. For these cases, these systemic cases to go forward, we need bona fide complaints. I get calls on a weekly basis of people telling me that their fair housing rights have been violated, this organization did this organization did that. Well, would you like to come in and file a fair housing complaint? No, I don't want to file a fair housing complaint because I'm afraid I'll get blackballed or I'll lose the housing, which is a real fear. I'll lose the housing that I am in at this time. One of the things about the Fair Housing Act is that retaliation is also a violation of the Fair Housing Act. And in most cases, in HUD litigation, it's handled more severely than the original complaint about housing discrimination was. But what we need is for you to be bona fide complainants. We can be a complainant in many cases, but what are the damages to our organization? And generally, the damages are slight to none. If we want to really impact a person, you get them in the wall. That will get their attention. And we need bona fide complainants for those reasons. The affirmatively furthering fair housing obligations are directly tied to a number of HUD programs, including CDBG and home funds. Municipalities and jurisdictions must conduct a serious assessment. This is the key change in the new affirmatively furthering fair housing guidelines. A serious assessment. In the past, we were required to do an analysis of impediments to fair housing, but there was no clear guidelines on what that analysis entailed. You could virtually make up whatever you wanted to do. You call it affirmatively furthering fair housing. Well, now it establishes steps to overcome those barriers and then establish an action plan and a timeline. HUD proposes to assist by providing mapping data and format. And I'm going to give you some examples of those things as we go on. This is an example in the tools of how to start. You can do your own, but they at least provide you with an example of how to do what we used to call an action plan. Okay? Pretty simple, not difficult, but it must be realistic. It must be reachable. The assessment of, it's now called, instead of analysis of impediments, it's now called an assessment of fair housing. Falsity to certify affirmatively furthering fair housing includes lack of an action plan, identifying shortage of affordable housing as an impediment, yet allowing NIMBYism. Less than 5% of CDBG clearly is not enough money for an assessment of fair housing. Less than 15% of CDBG is probably not enough as well. A poster contest, a proclamation that the city council or the county council reads out is not acceptable as an action plan. This is the famous case from 4 years ago that we've seen a lot. Go back one, please. Falsity in certifying affirmatively furthering fair housing includes Westchester County, New York. Was that a fair housing case? On its periphery, it was a fair housing case. The Fair Housing Act was not used to adjudicate this case. Falsification of documents was what won this case. Over 8 years and 1,100 times, covering $51 million, Westchester County built some affordable housing in already segregated neighborhoods, but they made false claims acts knowingly. They say every time that you get CDBG money, you must sign saying that you will affirmatively further fair housing. So 1,100 times of signing, falsifying that they were doing affirmatively furthering fair housing. That's what won this case, not fair housing. These are some of the things we've seen. These are some of the things that still go on today, on a day-to-day basis. We have opposition still. Opponents will try to describe the disparate impact standard as affirmative action, which it's not, as well as racial bean counting and closet quotas. Others will invoke the current popular phrase, big government, overreach of government. These are some of the other things that we've seen. Following Hurricane Katrina in New Orleans, there were a number of cases initiated by the Greater New Orleans Action Council. Okay? Simple things as blood relative rules, where if you already lived in a community that was 98% white, and the new rule became you could only rent to people of the same blood relation, then that effectively eliminated people of color from renting in this. When we can topple unnecessary obstacles to equal opportunity, we should. Blatant, overt discrimination is condemned and not tolerated, but today's discrimination is much more subtle and much more invasive. Opportunity, equality, common sense, and for the common good is all that we're looking for. Some of the other things that we've seen, again, after Katrina in Louisiana. Give me time to read, please. So the continued expansion of African American and Hispanic populations would require the city to consider planning and zoning changes. Isn't that what the city and the county should be considering? How to use affirmatively furthering fair housing as a tool. I'm going to talk to you a little bit about a case that we had going on while the Supreme Court was looking at Texas communities. The refusal to accept Section 8 vouchers is an impediment to fair housing and should be in every, it's no longer analysis of impediments, I'm sorry, analysis of impediments in Florida. If the AFH and comp plans state that the lack of affordable housing is an issue, then resistance from local governments to affordable housing development, insurance commissions, or NAIC, we'll let you read all that statement. They don't want us to see their actuarial scales. They don't want to tell us how they come up with their actuarial scales. Section 8 voucher program was intended to decrease segregation in housing. Not all things that HUD done have been magic fixtures to try to fix housing segregation and discrimination. In many cases, HUD has contributed to segregation and discrimination. Section 8 voucher program was intended to decrease segregated housing patterns and concentration of poverty by opening up areas of opportunity to low-income families. Areas of opportunity are places where jobs are relatively plentiful and access to education, health care, and other amenities is close at hand. However, exclusionary zoning, landlord disinclination to accept vouchers, and voucher holder preferences have been some of the barriers to that opportunity and continue to be barriers to that opportunity today. The disparate impact regulation and how it works, okay? There are some things you have to prove, you have to do in order to prove disparate impact. First, the plaintiff must demonstrate that the housing practice has a disparate impact on a protected group or perpetuates racial segregation in housing. So we may not have an individual that was discriminated against in this case. Let's take our case with the property we were just talking about, 17 units. Who are Section 8 voucher holders in the state of Florida? Predominantly single women, head of household, people of color, people with disabilities. We're going to have to prove that. They're not going to take that on face value that we say that. The burden then shifts to the defendant to prove that the challenge policy or practice has a valid business justification. So their reply is, this is business. Our actuary tables say that Section 8 voucher holders are a risk for damaging our property. That's their comment. Okay? Then if they do so, the burden shifts back to the plaintiff, us in this case, to prove that there are other less discriminatory means by which the defendant can serve the same interests. Okay. So now, most disparate impact cases deal with statistics. So in most of these cases, you hire your expert, They hire their expert and spend a few years, a few $100,000 each on your experts, and then you present your data in court. The disparate impact regulation explicitly prohibits refusing to provide property or hazard insurance for dwellings or providing such service as insurance differently because of race, color, religion, sex, handicap, familial status, or national origin. So our burden is to prove that their insurance policies do this. They remove the ability for people to be in housing because of race, color, gender, national origin, disability, no status. So we had to go out and get our own demographics. Fortunately for us, they weren't difficult to get. We didn't have to hire an expert. We went to the census. In the United States, with a total population, 13.2% black or African American, 12.1% disability. Section 8 voucher holders in the United States, 48% black or African American, 21% disabled. Break it down to Florida. Total population of Florida is 16% black or African American, 12.9% disabled. Section 8 voucher holders, 61% black or African American, 20% disabled. 61% Section 8 voucher holders, black or African American. So, Section 8 voucher holding have an impact on race? Absolutely. Disability? Absolutely. That's not enough. Now we have to break it down to our local community. Brevard County, total population 10.1% black or African American, 15.1% disabled. Section 8 voucher holders, 68%. 68%. Disabled, 20%. In the city of Melbourne, where this affordable housing complex was located, total population 9.8% black or African American, 15.9% disabled. Section 8 voucher holders, 50% black and African American, 28% disabled. Do our statistics back up the fair housing violation? Absolutely in this case. Historically, insurers have used underwriting guidelines to justify the failure to insure homes in inner cities and majority African American neighborhoods. These include guidelines based on the age of the home, lifestyle, credit history, employment stability of the home's occupants. Data and actuary analysis rarely exist to support those underwriting guidelines. They want to tell us that because of the age of the housing, the demographics of the community, the high crime rate, that makes the renters or the homeowners a bad risk. But the actuary guidelines do not prove that. Many underwriting guidelines traditionally used have no relationship to the risk, and they have no valid business jurisdiction. So we took this case to HUD, and we had a HUD mediator come to Orlando. We all met in June while the Supreme Court was hearing this case. It was a week before. And they had already decided, the insurance company had already decided and stated, we will change the policy. We will no longer use this policy. Let me back up a little bit and talk about the damages to the affordable housing provider. They lost their insurance. They had already paid their insurance for that year. It took them 3 months to get reimbursement for the amount of insurance that was remunerated to them. They had to go out and find another insurance company that would cover them at a higher rate. So they had financial damages as well as organizational damage. Section 8 is often used as a proxy for other forms of discrimination, negative stereotypes about poverty, race, rather than actual evidence that voucher holders bring crime with them or cause property deterioration. The use of code words to express racially motivated community opposition to particular programs is rampant. And I'm going to give you some examples. I'm going to go back to Louisiana. Camouflage racial expressions. Trigger words like ghetto, crime, blight, shared values, jeopardize safety, and falling property values. How many of you heard that? Because the people who are moving in here are losing the property values in this neighborhood. They're going down. It's called block busting in some cases. Greater burdens on community services and public schools. How many times have we heard this in community meetings in opposition to affordable housing? You're going to create a greater burden on this community and the school system. States' rights, forced busing, welfare queens, all trigger words to incite housing discrimination. Now, some of the other cases that we've seen, talking about trigger words and trigger phrases. We'll be having folks in Orleans Parish who lived in public housing complexes move over to Jefferson Parish. That's just not something I'm interested in. You didn't need those type of people for the lower ninth ward who didn't have a job, and mainly were people living off SSI and didn't have any disability, whatever. Trigger words to incite housing discrimination. Lack of actuarial justification and other evidence the insurance company did not have. So they had to drop that, and they were quick to do that. So then they said, we were in conciliation all day with the HUD conciliator. We weren't getting very far. But they had a flight to get back on at 6 o'clock that afternoon. So about 5 o'clock, the attorneys are out wandering the hallway and bump into each other accidentally, minus the conciliator. They throw the dice. And they say, well, the Supreme Court is hearing Texas Communities case right now. We think that we will prevail in that case. We will still settle with you for $90,000. But if the Supreme Court comes back in your favor and uphold disparate impact, we will settle for $150,000. Now then, the gamble comes back to us. How firm are we on the Supreme Court in the fact that they will uphold or not uphold disparate impact? And we're not. We're not firm at all. So do we take $0 or do we take $90,000 with the possibility of $150,000? We did that. Fortunately for us, 2 weeks later, the Supreme Court decided in favor of disparate impact, and we wound up with $150,000 instead of $90,000. But that's how a disparate impact case works. It's not an individual case of housing discrimination. It affects an entire protected group of people. You may or you may not have a bona fide individual. Generally, though, it's going to be more organizational. But the impact can be larger. If we had had an individual on that case, they may have been able to get 50, 30,000. We're not sure what we could have got. But because it was disparate impact, we managed to get larger. The fact that many insurance underwriting guidelines do not have statistical support, general lack of industry trade literature on the subject, social science research refuting any connection between crime and Section 8, lack of research suggesting any connection between Section 8 and most common insurance losses such as fire, weather, or water. That's what the insurance was supposed to be about: fire, weather, and water. No objective basis for the practice, as restrictions against Section 8 and the provision of insurance does not appear to be a common practice. We had another affordable housing complex less than 5 miles away. They had threatened to cancel their insurance because they had more than 15%. So the percentage wasn't even the same 5 miles away. And then they didn't cancel it. They allowed them to adjust the ratio of their tenants. We presented all these things as well. So let's go back to Affirmatively Furthering Fair Housing and the new rule. I had the book in the car and I need to bring it in as a display to you, and I forgot to do that. The final rule is 377 pages long, 400 pages long. The new Affirmatively Furthering Fair Housing rule. 3-inch ring binder, that fit. However, the assessment to fair housing tool and appendix is only 39 pages long. This is what you really need. This assessment to fair housing tool and appendix is what you need if you're going to do hopefully further fair housing now. This is the link to that tool. If any of you need the link or you want this PowerPoint after, just leave me your business card afterwards and I will email it to you. I provided it also to legal services, so they should have it. Under the assessment of fair housing tool, okay, remember we said it's nothing new. You still have to do basically analysis of impediments to fair housing. It's just got a different name, okay? But now HUD's going to provide you with better tools on how to do that and define it better. And they're going to give you maps, they're going to give you data sets, and they're going to give you tables that will help you do that. There are 16 types of maps, and I've just given you an example of 3 of those maps. Housing choice, vouchers, and race ethnicity. These are dot maps. You can pull it up on your individual locality, and it will give you a dot map on these types of things. Demographics and transit, public transportation. Demographics and poverty. There are 17 data tables. Again, I just gave you examples of some. Demographic trends, demographics of households with severe housing burden, and community assets by race and ethnicity. And you can bring these down to your own community level, your own designation, and you can refine them as you need to. Here's an example of one of those dot maps. So I pull up a dot map by race and ethnicity of Brevard County. Then I impose on top of that subsidized housing as well. Okay? In Brevard County, one of the few counties in Florida, we have a long, narrow county right on the East Coast. You can both literally as well as figuratively live on the wrong side of the tracks. We have 4 major cities in the county, from north to south. Titusville, Cocoa, Melbourne, Palm Bay. In Titusville, Cocoa, and Melbourne, all the public housing, all the traditional Black African-American communities are immediately to the west of the railroad tracks. You cross the railroad tracks and within 1 block from the historically Black community, and almost all the public housing. Down in Palm Bay, you see the cluster, the dot cluster, is a lot more spread out than Palm Bay. In Brevard County, you can go figuratively and literally live on the wrong side of the tracks. That's the kind of thing you can do with these dot matrix maps. And here's what they want you to do. They want you to do trend comparison. They want you to go back and look at the 1990 census, see what these maps look like. And then go to the 2020 census, 1990 to 2010, and see the difference in the trends in housing. And then if you can pull up data on 2015, you'll probably do that. They want to see the trends and change over that period of time. There are 40 contributing factor descriptions that you can use. Again, I just gave you an example of some of them. Access to financial services. We had a bank in our county. When I first started with the Continuum, my executive director at the time told me to look at community reinvestment and the opening of banks. And we just happened to have a bank that was opening a new branch, and they were advertising it. They skipped from Titusville all the way down to Palm Bay for the new branch. And they bypassed any neighborhood of color before they opened their new branch. That was one of the, so access to financial services, availability of affordable units, availability, type, frequency, and reliability of public transportation. What did we say in the area of opportunity was?
It's better jobs, better education.
Say again?
Better jobs, better education, better transportation, better services.
Exactly. All those things, okay? Community opposition to affordable housing, impediments to mobility, to be able to move out of neighborhoods that you don't want to be in or into neighborhoods that you do want to be in. Grantees can include their own data as appropriate. So, as you see, there's nothing new about what's required under the new rule. They're just giving you more tools and better equipping you with how to do it. Who is required to submit an assessment of fair housing? Jurisdictions and insular areas that are required to submit consolidated plans for the following programs: CDBG, Emergency Solutions Grants, Home, HUBWA, and Public Housing Authorities. All required to do an assessment of fair housing. There's some trigger phrases and trigger words in assessment of fair housing. Areas of opportunity. You're going to be required to identify what are the areas of opportunity. What are the patterns of segregation? Remember, they want you to look at least from 1990 forward. What are the patterns of segregation? At least from 1994. What is the access to opportunity? An assessment of fair housing. Assessment of fair housing tool. RCAPs and ECAPs. I always forget this one, so I write it down. Racial or ethnically concentrated areas of poverty. That's going to be a trigger word in your assessments. Change of segregation since 1990. Patterns of segregation since 1990. Those are some of the things that you're going to be looking at. Areas of opportunity and what equal housing opportunity provides. If we have equal housing opportunity, we have access to get to those jobs. We have access to health care. When we don't have fair housing, then we don't have access to those things. If a policy unnecessarily excludes people, then it's common sense that it should be set aside. That's been the law for 47 years. It's nothing new. And it's appropriate that it continue to be the law. Governments have a responsibility. In this age, the trigger words are big government, government overreach. Government does have a responsibility to ensure equal opportunity and freedom from discrimination for everyone. That's what affirmative voting for housing is. The Disparate Impact Doctrine safeguards everyone's right for a fair shot. Sometimes we don't have the individual that can come forward and explain how discrimination has affected them and the lack of their opportunity for equal housing. So we can use disparate impact to do that. Thoughtless housing policies can be just as damaging to a community residents as a willful scheme. And that's what we see more often than not now. Equal opportunity is the bedrock of American housing. That's what we talked about today. I realize I ran through those pretty quickly for you. If you have any questions, please feel free. I didn't get any during the presentation. So what questions do you have for me? I'll see if I can answer. Vince Larkins has just joined us from Palm Beach County. Does the same thing that I do. Between the two of us, we ought to be able to answer some of your questions, please.
I'd like to start with a question myself. You mentioned earlier in the presentation a community land trust in the park. It's kind of, I understand it's an expensive area. I was wondering if you could talk a little bit about how much, if any, impact you got from that and how you would think.
Okay, I didn't help set up the community land trust, so it's difficult for me to answer that question. But Winter Park is a very expensive portion of the city of Orlando. It's within where this community land trust housing is within walking distance 4 or 5 blocks of downtown Winter Park, which is very upscale shopping, dining, and everything. So the only way that affordable housing could possibly come into this area was through a land trust basis. We finished a house there last month for a veteran just coming out of his rehabilitation, completely accessible. It's a manufactured home. There's no way you could really tell it's a manufactured home by driving down the street. It was brought in, set down on the property, fully accessible for him and his family. And we're looking at building 2 more houses in with the Hannibal Square Community Land Trust for female veterans in the near future as well. And that's all from money from our community reinvestment from our REO project, system.
Did that mean with any kind of community resistance in that area?
We have not, I have not experienced it for this particular project. For the Heroes Commons, we are getting some kickback from people who say they're in the community, but it appears to me that most of the people that were in the audience complaining about high crime and the police not doing enough about high crime were the slum landlords who are owning apartment complexes and things in Paramore. Paramore is a historically black community immediately to the west of I-4 in downtown Orlando. So on the east side of downtown, all your skyscrapers, your banks, your big condominiums, then immediately to the east of I-4, historically black neighborhood, and admittedly high crime, a rough neighborhood. We brought the police in to talk to them about that. Paramore has more security cameras than any other neighborhood in the city of Orlando. Is it affecting the crime? We don't know. We can't prove one way or another whether it's having an impact on crime. Is that my time remaining? Thank you. Any more? We got, she says, about 4 minutes. Any other questions? Yes, sir.
All right, one quick question. Going back to some of the insurance industry practices of, what they utilize to assess risk, the age of the, we're talking about age of the housing and some other things. If there's no actuarial analysis to show that these factors really indicate risk, why do you think that what motivates them to press to continue with these business practices?
Well, the actuary data that they have, age of the housing, replacement cost of the housing, those are all real things. And that lets them know how much it will cost them to cover a property and if they have to pay for rebuilding the property. The thing that they can't prove in their actuary tables is that because you're a Section 8 voucher holder, then you increase the crime, you are a poor resident, you don't maintain your property. Those are the things that they cannot prove, and it's not in the actuary tables. And those are based solely on stereotypes. Any other questions?